Okay, hello everybody. Welcome to the session on financial statements and orders to enforce disclosure of family law in family law cases. As I'm sure you know by now, my name is Lois Shelton. I'm the Legal Advocate Manager at the Law Foundation. I use the pronouns she and her. I want to acknowledge that I live and work on the lands of the Coast Salish people, the Musqueam, the Squamish, and the Tsleil-Waututh nations. So today our speakers are Vicky Law, who is the lawyer at the Virtual Legal Clinic and has worked in family law for several years. And Haley Rymack is one of the FASL lawyers now. She's the, as I understand it, the education arm of FASL these days. I won't say more, but if you want to explain your positions more or go into that, I leave it to you and hand the presentation over to you.
Thanks, Lois. Yes, I'm the Virtual Legal Clinic lawyer at Rise Women's Legal Center, and Haley is my beloved friend and colleague and coworker. She is so amazing. If you don't know her already, she wrote this amazing report beginning of this year about the family law courts. It is rather long, so it's not a nighttime read, but I do think everyone should take a look at it. It's just amazing, amazing job. We are here today to talk to you about financial statements and orders to enforce financial disclosure. Haley and I will be going back and forth and talking about the various things that you can do to enforce an opposing party in your client's case to provide financial disclosure, because I think that you may all would like to agree with me that sometimes getting financial disclosure from the other side is like pulling teeth, if not worse. I probably would rather go to the dentist and try to enforce some of the opposing parties to provide disclosure. And yes, so it is difficult, no doubt about it. But there are ways that you can enforce financial disclosure orders and make the other party do what they are required to do. As always, nothing that we say in this presentation is legal advice. It is for information only. If you need legal advice, please speak with your supervising lawyer or Rosanna or any other lawyer you may know. And also either one of us. We can also help it sometimes, I suppose. Just kidding. All the time, always here for help. Please feel free to email us. Okay, overview. This is what we're going to go over. I know this looks like a lot in the amount of time we have together. I promise that there will be breaks. I am going to ask Haley to watch of the time and remind me when I need to take a break. And she's nodding. I see her nodding. So yes, thank you, Haley. But we are going to go over what financial disclosure requirements are. Like, what are they? Who needs to do them? Why do we need to do them, etc. We're going to look at some orders in the Family Law Act and some orders that you can use to enforce in both the Supreme Court and the Provincial Court. And then we have one little case law that Haley's going to share with. I am quite proud of this case just because I was on the case committee for West Coast Leaf and Leaf National. But, that's just a bit of humble bragging on my part. I did not do anything. I was just sat on the committee. But all right, moving on. Who needs to complete a financial statement? And I'm going to talk about financial statements broadly in both levels of court right now. In a little bit, I will split into Supreme Court and Provincial Court. But generally, who needs to complete one? So I think the rule of thumb, and it's easy to remember, is pretty much any time there's a claim relating to money, a financial statement is necessary. So anytime you have someone who wants child support or Section 7 expenses or spousal support or they're like, I want to divide this debt, or I want to divide this property, you are going to need to do a financial statement. Sorry, your client is going to need to do a financial statement. And so I've listed out all the issues: child support, spousal support, and child support obviously includes Section 7 expenses, or if there is a division of property and or debt. The exception to this rule, and I promise that there is no exception to the exception, because I know lawyers like to make things difficult. And when I took rules of evidence, there was always exceptions to exceptions, and I did not like that. But this is the only exception to the rule, I promise, is that if the party is claiming only child support, so basic child support table amount, they are not claiming Section 7 expenses, they do not need to complete a financial statement. So I'm going to repeat the rule again. The rule is any time that there is a claim relating to money, where there is a dollar sign, you need to complete a financial statement. The exception to the rule is if your client is only claiming basic child support. And when I say basic child support, it means only the child support amount based on the table, and they are not claiming Section 7 expenses. I think that rule is fairly easy to remember, but if there are any questions about that, I want to pause there to let you, please feel free to ask me any questions about that.
Hi, Vicki, it's Frances.
Hi, Frances.
My only question is, does that exception still apply if it's shared parenting?
No. So I do have another slide. You're moving ahead of me. Sorry. So part of the exception, I guess I should put in here, is if one parent has the majority of the parenting and they are only asking for basic child support, there is no Section 7 expenses, then they do not need to complete a financial statement. Thank you for clarifying, Frances. I appreciate that. But yes.
Thanks.
Any other questions? Okay, moving on. So as you can see, Frances obviously can read my mind. The first bullet point here is financial statements are not necessary when clients are seeking child support for children under 19. So that's the other caveat, is if the children are over 19, then yes, you do need to do a financial statement. The children are not stepchildren, so the payer is not a step parent, and the children are living with the applicant 60% or more of the time. Another situation where you don't need to do a financial statement is when the client is claiming for only divorce. So you're claiming for divorce, there is no money to be argued about, don't need to do a financial statement. The other situation is you're seeking orders regarding parenting time that does not affect child support. So you want to change parental responsibilities for some reason or another. There is no change to the 60-40 shared parenting time. You don't need to do a financial statement. The next situation would be if you're seeking conduct or protection orders only. Again, not about money, not about a dollar sign. You don't need to do a financial statement. And then the last point I just want to address is that not all portions of the financial statements need to be required. Right now, for both financial statements, and when I say both, I mean the one in Provincial Court and the one in Supreme Court, there's quite detailed information at the very beginning about it. It looks like a table and there's a chart, and it tells you which parts that the client needs to complete depending on what they want to claim. And so it may be a bit confusing, but I do encourage people to look at that if you don't know which part you need to complete. But that gives you a good guidance on which sections you need to do. Unfortunately, we don't have time today to go over exactly how to fill out a financial statement. And I think some of you may have already attended that session in one of your trainings. And I'm happy, or Haley might be happy to do that at a future training if there is a request to do that. But unfortunately, we won't be going over a financial statement today. One thing that I do want to note is it's kind of unclear in both the financial statements right now. The section about undue hardship or providing information about the income of other people in your household. So let's say that you have a client and they have a new partner, or they're living with a family member who is working. It's unclear whether you need to provide the income of that individual on your financial statement. And I just want to be clear that you do not need to provide that type of information unless the client or the other party is claiming for undue hardship. So if your client is the payor and the payor is claiming undue hardship, then they do need to provide that type of information on the financial statement. But otherwise, you don't need to disclose that type of information if you're the recipient. Okay.
I just want to add that, Vicki, you're doing a session later as well on how to read financial statements and go through them, as well as business statements. So anyone who isn't super familiar with completing the financial statement, that will also be a really helpful session because Vicki will go through how to read it once you receive it, which will help you to better write them as well with your clients.
Thanks for the reminder, Haley. Thanks for reminding me that I'm doing that session. I do remember, it's in my calendar. I just haven't prepared for it yet. But so if any of you are attending that session and you have questions or you want me to go over something next week, please let me know, like put it in the chat or something. Because obviously I haven't spent a lot of time preparing for that session yet, so I can cater it to you. I'm not looking at the chat, but I'm assuming, Haley, that you are. And if there is anything, you will let me know.
Yes, for sure.
Great, thank you. Okay, so I'm going to talk about for the financial statement requirements in the BC Supreme Court first, then I will talk about the Provincial Court. So the BC Supreme Court is on this slide. We are talking about the Supreme Court Family Rules 5-1. There is a typo there. I apologize. It says 5.1. I think I meant to say 5-1 here. So the financial statement in the Supreme Court is called Form F8. And if a party is making a claim that requires them to complete the F8, then an F8 needs to be filed and served within 30 days after the service of the document in which the claim is made. So let me break this down because that might be a bit confusing. In the Supreme Court, your initial pleading, the original pleading, is the notice of family claim. If the client is, let's say, claiming for property division in the notice of family claim, they need to file and serve the financial statement 30 days after serving the notice of family claim. Okay. If your client did not make a claim for any financial issues in the notice of family claim, but the respondent makes a claim in the counterclaim, then the respondent has the obligation to file and serve the financial statement 30 days after they serve the counterclaim. So that's the respondent's responsibility. Now we're going back to the claimant. If the claimant needs to provide a response to the counterclaim, which I always recommend you do, if the other party makes a counterclaim, you should always provide a response. Then the claimant has 30 days from the date of serving the response to counterclaim to complete the financial statement. Okay? that is the rule. Do people follow it? Absolutely not. They do not. It's really, really, really rare, I think, for people to follow this rule, despite it being there. But I think it's best practice, obviously, to follow it because you're going to need to do it. The court will require you to do it, require your client to do it. Court can't move forward unless there's a financial statement. So if you find that your client cannot meet the deadline for the 30-day deadline, I would, if there is opposing counsel on the other side, I would just assist your client in writing a quick email and saying, we know this needs to be done. We're working on it. We'll get it to you by such and such a date. And I suggest actually give a date so that you can provide it by, because if you say, oh, we'll give it to you 2 weeks from now, and then 2 weeks from now you need more time, then you're going to have to let them know again that you need more time. So even if it's we'll provide it to you, 30, within 30 days or next month or something, or by the end of November, just say that. They're not going to be well, no, the rules say blah, 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 because chances are they also did not provide a financial statement within 30 days. But it's the obligation of our clients, and we just want our clients to look the best in court, right? So that's what we're going to do.
Vicki?
Yes.
Vicki, we're hearing a conversation in the background. Can that possibly be you?
Do you hear it right now?
I think it is you.
Okay, you know what?
And I just asked people at Rise to to know that we're
if you don't mind, I'm just going to mute myself for a moment while I tell them to be quiet. 1 second.
Okay. That's so.
Yeah, it's a small space, and students are working with clients on the phone kind of close by. So it's hard for everyone to be super quiet.
Yeah.
Sorry, I lost my last point. I'm
It was
looking
about
to you.
wanting our clients to look good by meeting the deadlines.
Oh, yes. If you can't meet the deadline, let opposing counsel know. If there is opposing counsel on the other side, give them a realistic date of when your client can provide the financial statement. And then, of course, do everything to file and serve the financial statement before the court appearances, because like I said, the financial without the financial statement, the court really can't do anything. And for those of you who have assisted clients in the Supreme Court, they're really focused on property issues like parenting time and parenting arrangements. They're like, oh, let's focus on the property, like what's going on there. And, maybe one party, your client really needs child support, or child support can't be ordered unless there's a financial statement done. Usually, in most cases. And then the other tip that I have is, if it's not an urgent application or there is no urgency in filing the notice of family claim, my practice is just to do everything at the same time. So do the notice of family claim and do the financial statement. Once those are done, you can give it to the client. The client can file and serve both at the same time. And there's not this, okay, let's do the notice of family claim, and then we have to rush to file this financial statement 30 days after. Because if you don't file the notice of family claim, there is no clock ticking for that. So again, obviously it's not possible in every situation, especially if you have like an urgent parenting matter or a protection order that you might need to do. That's not possible. But for someone who doesn't need to go to court right away and has the ability to do the financial statement at the same time, I do recommend doing that because it helps a lot. Then the next thing I do want to say is that if the opposing party is outside of Canada or US, so outside North America, they actually have 60 days to file a financial statement instead of the 30 days that I was talking about before. I just want to check in about the audio. Are you still hearing things in the background?
It's
No,
way
it's
better.
great.
Yeah.
Okay, great. Any questions about the Supreme Court before I move on to the Provincial Court? Okay. The Provincial Court is very different. As you may know, the rules are very, very different. So the rule for the Provincial Court is you must file and serve a financial statement when you are initiating the claim for support issues. So if the client is the one who is initiating the application about a family law matter, Rule 25 says that they have to file the financial statement. Rule 28 says if you are replying to a family law, an application about a family law matter with a counter application, then you also have to file the financial statement. And then Rule 34 is if you are replying to a counter application about a child or spousal support, then you also have to file the financial statement at the same time. Depending on the registry that you're at, and I am most familiar with the Robson Square Vancouver registry, they are quite sticklers about this. I have tried to file applications without this financial statement, and my documents have been rejected. So if you have a good relationship with your registry, your local registry, and they let you do that, file applications without financial statements, please note that you are very, very lucky and do not take advantage of that. Keep them happy. Whatever you do, keep them happy, because according to the rules, you have to file a financial statement. That's, again, just know your registry and know what their practices are. Don't be surprised if you show up with an application or a counter application or a reply to a counter application and it gets rejected because you don't have a financial statement. I'll keep that in mind. Questions about that procedure in the Provincial Court? Okay, so I do talk a little bit about financial statements and how to start them. I find that out of all the other forms, this one, the clients are most overwhelmed with the financial statement because they see a bunch of numbers, they see a bunch of lines, they see a bunch of stuff regarding tax documents or tax returns and notices of assessments, and they're like, where do I even start? So these are the first things that I tell the client to start doing even before looking at the financial statement. I explain to them what the purpose of the financial statement is for. I tell them if there is any deadline and that we could push the deadline if there is an option to do so. I tell them that. And then the documents that they should provide. So at the very minimum, we'll need the last 3 years of notices of assessments and the last 3 years of tax returns. That applies to everybody. Okay. And if the individual is employed, we need the most recent pay stub from their employment. Or if they are on income assistance, then we need some documentary proof to show that they are on income assistance. And sometimes it's as easy, depending which office your community is at. If there is an office, it's as easy as going to the office to say, I need a paper to confirm that I'm receiving income assistance. Sometimes that is not so easy to obtain. And sometimes the client's like, well, they just put money in my bank account. And so I say, okay, well, let's print out your bank account statement and redact everything else, like black it out, because what the client spends money on is none of the business. Where they go is none of the other party's business, and just leave that deposit from income assistance readable on the bank statement. Okay. I always tell clients to start with the expenses first. So part 2 of the F8 or part 3, the property debts and debts, because that relatively those 2 sections are easier than the income section, which is a bit more complicated. I always remind the client that a financial statement is an affidavit. It is a sworn or affirmed document that needs to be true to the best of their ability. And obviously, financials change over time, whether it's the income that the party is receiving or the expenses that party needs to incur. Clients will always have the opportunity to update if and when it's necessary. And actually, there is an obligation to update that if it's necessary to do so. So it's not that, what they put down on paper needs to be forever the same. That's not true. It just needs to be true for that moment in time. And they can always explain any changes that they might expect. Like, for example, clients who work a lot of overtime the year before, they may not be expected to work overtime this year. They can explain that in the financial statement. Or people who are on commission-based, their income fluctuates quite a lot depending on like the season. Like, for example, if it's the holidays, obviously, if they work in retail and they're commission-based, their income would be a lot higher in the holiday months as opposed to right after, for example, right? Okay. So moving on to, that was more about how your clients can complete the financial statement and who needs to complete a financial statement. Now we're going to move on to talk about what if the opposing party is supposed to give a financial disclosure and a financial statement, but they are not doing so. So what can you do to help your client to get the opposing party to give your client what they need? Excuse me. Okay. So we're going to first talk about the Family Law Act. There's 2 sections in the Family Law Act that I want to address. The first one is Section 212 of the Family Law Act. Section 212 allows the courts to make an order to disclose information in accordance with the Supreme Court family rules or the Provincial Court family rules. And if an order is made under Section 212, then the court can also order a party to pay to the other party, so in this case, your client, or another person, all are part of the expenses that is reasonably and necessarily incurred in complying with an order. So what that means is sometimes bank statements are necessary to ascertain someone's income because they haven't done their taxes in the last 10 years. They're not planning to do so. And now we need bank statements to look at how much money has been deposited in their bank account. That is something that can be ordered. And most people can get their bank statements online, so there is not a cost incurred. But sometimes you can't get it online. And if you go to the branch of the bank, they actually ask for clients to pay. And I think it's like $1 a page to produce the bank statements, which is fine if it's like 5-10 pages. But most of the time it's not, right? Like most of the time we're going to be asking for years of bank statements going back. The most I think they can do is seven years, I think. So 7 years of bank statements at $1 a page, it gets pretty expensive. So that's why you would utilize this section of the Family Law Act to say, well, if my client's being asked to obtain all these bank statements and the other party wants them, well, the other party should be paying for it. So that's one thing you can ask so that your client isn't incurring all the expenses. But obviously, if your client is asking for the other party to obtain the bank statements, your client doesn't want to be paying for that expense. And so the alternative argument would be, he's the one that didn't do his taxes for the last 10 years. And that's why we are now needing to go through the bank statements. Every individual has an obligation to do taxes. So my client shouldn't be the one incurring that cost. So it's a double-edged sword, depending on which side you stand, but I think there are arguments for both here. And it's important to remember that the individual requesting this order for disclosure cannot disclose information to other people except when it's necessary to resolve a family law dispute. So, you know, if Sally obtains Frank's financial statement, Sally just can't be putting it up on social media and like giving it to her friends, you know, when they get together, or, you know, telling Frank's sister, oh, look what Frank spent on this and that. That's not okay. You can't do that. It's only used for the resolution of a family law matter. And then the next section under the Family Law Act is section 213. And 213 relates to 212. So 212 allows the court to make orders for disclosure. 213 allows the courts to enforce the orders made under 212. So let's say Sally did get an order from the court saying Frank has to disclose certain things. If Frank still fails to comply with such a court order, then Sally can use section 213 to enforce the order. So what the court can do here is they can continue to make an order under section 212, which is kind of silly because there's already been an order under section 212, and essentially you're asking the court to make a second order under 212, forcing Frank to disclose financials. The court can draw a negative inference, which means that, well, you know, Frank was ordered to provide this information. Frank's not providing it. So the court can say, well, you know, Frank's an engineer in this firm, and engineers at that firm make such and such amount of money. So, you know, I think that Frank could earn $100,000 and we're going to impute income to him. And that's called a negative inference, because Frank can be like, no, I actually make $60,000 a year. But the court's like, well, you didn't provide any evidence, you didn't provide any disclosure. So we're going to draw an inference against you until you do such things that we ask. Require a party to give security, meaning giving security to the court, like, you know, $1,000, $2,000, so that if they don't comply with the order, they forfeit that money. They can fine the person for non-compliance, and the fine can be up to a maximum of $5,000. Require the party to pay all or part of the expenses for non-disclosure. So if Sally incurred some expenses because of Frank's non-compliance of the order, then Frank could pay back the money that Sally spent. Another amount of $5,000, a maximum amount of $5,000 paid to the party affected by non-disclosure. So the court could order that Frank gives $5,000 to Sally, and any other orders that the court deems appropriate. So depending on which court you're in and which judge you're before, they can order other things for non-compliance. And sometimes people ask me, $5,000 is a lot. Does a court order it? And what I say is, if you don't ask for it, you're not going to get it. And so I think everyone should ask for it, especially if this non-disclosure has been repetitive. So it's not just been one order, but 2, 3 orders that they haven't been complying with. Ask for the $5,000. The court probably won't provide it, but I've gotten fines before. I've gotten, I think $1,000 or $2,000. I did ask for $5,000. but I got 1 or 2. But like I said, if I didn't ask for 5, I probably wouldn't have gotten any. So that's important to remember.
Also, in just to add, in making your submissions or in kind of preparing for what the $5,000 represents, it's usually so costly for people to have had to go through these next steps to make all these applications in order to get this order for something that should have really originally in the most circumstances been provided. So in terms of like what the fees are, that really justifies as well asking for the maximum, because a judge can kind of understand where you're coming from. I don't think it's not unreasonable that a person could have had to spend $5,000 in legal fees theoretically. Vicki, do you think we should take a quick break?
Yeah. Okay, why don't we take a 5-minute break? Thanks for sharing. And we'll take a 5-minute break and come back to this. So we'll meet back again at 1:45. Okay, so we talked about enforcing the financial disclosure in the Family Law Act. Now we're going to move and talk about the financial disclosure and enforcing financial disclosure under the BC Supreme Court Family Rules. That's what the acronym stands for. BC SCFR is Supreme Court Family Rules. 5-1 is where the rules regarding the financial disclosure is required. So I invite everyone to, when you have time, to take a look at the definition of applicable income documents under 5-1. It's quite long, and I've only highlighted the few here that I think are most relevant. But like I said, with any financial statement, you need the last 3 years of tax returns and the last 3 years of notices of assessments or reassessment, the client's most recent pay stub, or if the individual is receiving income assistance, then documentary evidence of that if you can obtain it. If your clients are like my clients, completing a financial statement for them can be fairly easy because they are not self-employed. A lot of them do hold they are an employee with an employer. They're able to obtain a pay stub and they get a T4 and they file tax returns with their T4 and then they receive their notices of assessments. However, a lot of the opposing parties in my files, they are self-employed. And that I will discuss more about that at the next session next week. But trying to obtain financial disclosure from self-employed individuals can be quite difficult because they don't have a T4, they don't have a pay stub, they do their and if they do their taxes, they write off a lot of their things. So their gross income and net income are quite different. There could be, a difference of even $100,000 I've seen. So if your client or the opposing party is a self-employed individual, please read that section under 5-1 sub 1. It talks about what documents are required when an individual is self-employed. And then I also want to point out sub rule 13, so 5-1 sub 13, which talks about particulars can be demanded when the financial statement, the F8, lacks sufficient information. What that means is that if the financial statement that was provided to your client is not sufficient, you think that there's missing information. For example, you know that the opposing party is self-employed, but they do not fill out the business interest section, then your client has the right to demand for more information. And that's essentially what particulars mean, is that they can demand more information and demand for specific information. And just Another sub rule that I want to let everyone know about, because this can be missed a lot of the times, is the Supreme Court actually requires parties to keep their financial information current. And so if there are any material change in circumstances under the rules, the person who has that change has to provide a new financial statement and also a written statement outlining what the changes are. So that's important to note. And then the last one, I put them out of, I realized I went 13, 15, 14, but sub rule 14 is the court can order particulars if the financial statement doesn't have enough information. Okay, this is all great. You're like, Vicky, yeah, these sections work really well, but how do I help my client get to that? If we are in court, how do I utilize these sections? So I'm going to talk about how to utilize these sections in the Supreme Court, and then Haley's going to talk about how to enforce these orders in the provincial court. In the Supreme Court, you need at least 2 documents. So you have the notice of application and the affidavit. So in the notice of application, I've actually written out the wording here where you would want to put the section that says orders sought. This is what you would put under orders sought. So pursuant to section 212 of the Family Law Act and the BC Supreme Court Rules 5-1, an order that the respondent or an order that the claimant, if your client is the respondent, shall, by 30 days of the order, file and serve the following documents. And so what I've listed here is a financial statement and all applicable income documents as per Rule 5-1. Your client may want additional documents in addition to the financial statement. But let's say you haven't even gotten the financial statement. This is the type of wording that you probably want to use. Now, I put 30 days here because that's generally the practice is 30 days. But if there is an urgent application, like let's say you have trial in 2 weeks, or let's say you have trial in 28 days, you're obviously not going to want the financial statement in 30 days. You want it earlier. But this is why it's always, you want to think ahead of what's the next step in the litigation. Is the next step going to a JCC? Is the next step going to a trial? Are you going to, is there a mediation scheduled, right? What's happening? And so if you need a financial statement before the mediation or before the trial, you don't want it to get it on the eve of trial, right? You want the client to look at it. The client needs to go to a lawyer, and probably the lawyer can look at it to give the client some advice about the opposing party's financial statement. So just, even though it says 30 days here, keep that in mind. You probably want it much, like at least 3 months before the trial. Like in my ideal world of trial preparation, I would love documents like 2 to 3 months before trial starts. But that doesn't happen because not everyone is very organized, and I am included in that statement. There's no way that I would be able to provide all the documents to the other side 2 months beforehand. But we're talking in ideals here. So that's the notice of application. In your affidavit, you want to list out the history of litigation. So when the parties started the litigation, when was the last financial statement provided? Were there any orders for financial disclosure? Have there been any requests made to the opposing party or to the opposing counsel for financial disclosure? And requests should be made in writing, right? They should either be in letters or they should be in an email, because those can be attached as exhibits to the affidavit and say, on June 1st, 2021, I wrote to the opposing counsel to ask for them to provide a financial statement for the respondent. They have yet to provide one. Attached as Exhibit A to this affidavit is my email to the opposing counsel on June 1st, 2021. You want to attach all those. And those emails, not inflammatory, they're not accusatory, they're just say, please, in accordance with the rules, provide Mr. So-and-so's financial statement. And you want to do it that way because you want to show the court that you've asked for it. You don't need to go into, and I know the client sometimes wants to do this, is like, they didn't follow the rules. I followed the rules. Why can't they follow the rules? I don't have a lawyer. Don't need to go into that. They didn't do it. They were supposed to do it. End of story.
I just add to, oftentimes it'll be kind of a mess about what has been done and what hasn't. So the clearer your affidavit can be on when things were requested, and what has been provided, because some people will be providing bits and pieces of things, which sometimes makes it almost worse because it looks like they've disclosed all these things. And then you get to court and it's, if you haven't clearly outlined what has and hasn't been disclosed, it's harder for the judge to kind of go through everything and really see what is still missing, because that's the point, is that they haven't met the orders or the obligations, and it's insufficient to still get that information that you need. So kind of the clearer you can outline what has been, what hasn't been disclosed, when the requests have made any orders, it'll be easier going forward.
Okay, Haley, over to you.
Okay, thanks, Vicki. So before I start, I was just looking at everyone, and I know most people have their cameras off, which is no problem, but I was wondering if anyone other than Francis, thanks for your amazing example, has made these types of orders either in Supreme Court or requests for the enforcement of financials. Anyone has any familiarity with the new forms for that? You can put up your hand. I'm not seeing any hands. Okay. Just curious. Sarah, no, thanks. Shaking, no. Okay, great. Well, so we're going to talk about case management orders, which is section 61 to 65 of the rules, and it's also Form 10. And then the main thing I'm going to talk about is Form 29, which is the preparing an application about enforcement in provincial court. Okay, so the case management orders in provincial court, people might be more familiar with this form or these rules. We've talked about it, I know, a few times throughout the trainings, and it's maybe come up quite a bit in your practice. They can be made at any time, and the rule states that a judge can order various pieces, including respecting the conduct of a party or management of a case, including pre-trial and trial process and evidence disclosure. So this is kind of encapsulates potentially the order to enforce the financial disclosure. And what may be happening for your client is they're wanting to have a case management order or make that application, and they have various pieces that they want to bring forward, and that may make this form more suitable to them. Next slide, please. So here is just the link to the rules that go over it, as well as the form on preparing an application for case management order. Next slide, please, Vicki. Okay, so Form 10 is the actual form, and it can be used to apply for one or more of the following: adjourning a court appearance, transferring the court file to another registry, requiring a parentage test, setting a specified period for the filing and exchanging of information, et cetera, et cetera. So it's this nice sort of catch-all form to have this case management order, and this could be one of the options that you take for enforcing the financial disclosure. Next slide, please. Thanks. What's more specific to the enforcement of an order is its own specific form, and that's Form 29, and it's titled Preparing an Application About Enforcement. So when parents or guardians don't follow written agreements, court orders, or a determination of a parenting coordinator, you can apply for an enforcement of the order. If you have a written agreement or a court order from another jurisdiction that's filed in a provincial court in BC, you can use this form to enforce it. And lastly, this form the purpose of it is also if someone receives notice of a foreign order, you can request to set it aside using this form. And the way you would do that is you do it within 30 days of receiving that. And if you're applying to set aside the registration of a foreign order, you also give notice to the designated authority who will notify the other party of the application. So that's all kind of a lot of words to say that there's these two really main purposes to use this form. The first one is for orders enforced that are already filed in provincial court, and those orders are about what's in that first bullet point there. Court orders or determining parenting coordinator or the enforcement of orders. And then lastly, receiving a foreign order that people are seeking to have applied. Oh, did someone unmute? I'm hearing. No, okay. So I'll go through that a bit more in the next few slides. So Rule 135, don't worry, I won't read all of this. It's just sometimes helpful to go back to what's in everyone's mind when they're making these forms, and how do the rules and the forms all come together. So Rule 135 is what's guiding this form. And it's about applying for an enforcement of an order, and a party who is applying for an order about any of these following must file and serve the other party at least 7 days before the date referred to in the application of the court appearance with that Form 29, as well as a copy of the agreement or the order that they're talking about. So as you can see, there's really specific things such as denial of parenting time, but then there's also just enforcing orders generally. So this is a good catch-all piece of the way of having orders enforced. Okay, next slide, Vicki. Thank you. And then Rule 136 is also what's catching that second main use of this form, which is the when people are applying for having their other orders enforced within a BC Provincial Court. And that's captured under 136, exactly what someone must do. So there's the service requirements there, and how long, how much notice they have to give, and how they can give that. So just for your information, that's where that is. I'm not sure if that comes up too much. Next slide, thanks. Okay, so you may be wondering, what if my client doesn't have the ordered that they're wanting enforced actually filed? So that's a different form. So you file a request to file an agreement. For example, this would potentially be like if there was already an agreement about say a separation agreement that was, that for some reason hadn't been filed, I guess, then you would file the written agreement with this Form 26. And I've looked through the form. It's quite simple. It's almost like a cover page that just goes through the information. And then really it's just a way of attaching that to the written agreement and then filing it with the provincial court. So that's sort of the first step, because this Form 29 only works if your agreement has been filed. So you first must file it. And then Form 27 is is another exception, because this again was about the determination of a parenting coordinator. And that's one sort of exception. I know that's not related to financial disclosure, but I wanted to include it because in looking at Form 29, they really go through all the exceptions for when that form isn't suitable, just to be clear. And then potentially your client has an order in BCSC, so in Supreme Court, and you want it enforced in provincial court. That's a different form as well, and that's Form 28 to file an order and have it enforced in provincial court. And yeah, does anyone have any questions about those? Or Vicky, I meant to ask you before if you could think of a circumstance when someone's wanting an enforcement in provincial court. Maybe I was thinking if they had, actually couldn't really think, but maybe if they had almost resolved everything and there was this last standing issue that could be dealt with in provincial court.
Do you mean like enforcing a Supreme Court order in a provincial court?
Yeah.
Yeah, that's odd. I've never actually seen that. Like if you had started a matter in Supreme Court and now all of a sudden you want the enforcement to be done in provincial court, that is odd to me, but perhaps you just want the payments to be enforced, which, FMEP will do eventually. They may step in at some point to enforce the payments. I've been very vocal about this, and I'm not shy to say that I might be boycotting the provincial court because there's so many rules and so many forms, and I don't like it. But that's my personal preference, and I know that it's not possible all the time.
Yeah, there's, I was just thinking in preparing this and looking at all the rules and forms and how they intersect, there's just so many scenarios where if anyone has questions, I was thinking about questions, I was just going to direct them to Vicky Law to hopefully be able to answer them, because there's some scenarios where I was thinking I don't know exactly what form they should start with, but anyways, that's why I was also wondering how people's experience with the forms had been, and I would secretly side message an advocate who had done the process if anyone asked a question about a specific thing.
Yeah, I think if you had a Supreme Court order and you were trying to enforce it, my recommendation would just be stick to Supreme Court. I know it's more money. I know it could be scarier because there's costs that could be awarded against the clients. But now with the new set of rules and the new set of forms in provincial court, I honestly don't think the provincial court is more user-friendly anymore. I would have said that in the old rules, but I no longer believe that it is true. However, that is my own opinion. If you really like the provincial court new way of doing things and you're really comfortable with the rules and forms, by all means, go ahead and help your clients do that. And please also teach me how you got so comfortable with them, because there are times where I feel very frustrated.
Yeah, and another thing that, just not to make this about this random Form 28, another thing that I think of is we're often trying to direct proceedings to go through provincial court, because that's, there is always a risk of costs in going to Supreme Court. That's where we would rather things be in provincial court for people who can't afford to pay costs. So, but in doing that, we know that there's a lot of counsel, like if the other person is represented, who don't like to go to provincial court because of the things that Vicky has outlined, but also because they're working with paying clients. If they're going to go through court, it's the fact that there is potentially costs is a benefit to them in proceeding and that type of thing. So I was just thinking of this, people could, be trying to go to provincial court, and then you can actually then have the whole matter moved back to Supreme Court if the opposing counsel makes that application. So next slide, please. Enough on that. If anyone uses it, please let us know. I'm sure there's very good uses for it. I just am not sure how it would play out. So because I was going through the forms, I know that everyone knows this, but I just wanted to do my due diligence and outline, what kind of pieces of information you're going to be including, just in case, people still aren't as familiar with them. So you're going to do the 3 copies of the form. And if you're faxing it, there's another form for that. You're filing it at the registry most appropriate for you. And then you're serving the opposing party with 7 clear days. Clear day means not the service date and not the court date, 7 nice days in between. Okay, next slide, please. Okay, and that kind of brings us to just some pieces. I wanted to give a quick excerpt from this one case that's from 2013, where the Honorable Judge Merrick says, while I am of the view that the failure to pay child support will often not constitute an act of family violence when the failure is the result of a determined decision not to pay, knowing the impact it would have on Ms. B, who had limited income, and my rejection of Mr. P's explanation for failing to pay, I have concluded that this was designed to inflict psychological and emotional trauma and is therefore an act of family violence, with emphasis added. So, one of our big interests in this topic is we see a lot of people, as I'm sure you all do, that have been going through these court processes and they just can't get further along to what they're actually seeking oftentimes, which is the financial support that they need for their child, because the other party refuses to disclose, refuses to fill a financial statement. They're self-employed. They show you that they make $10,000 a year, yet they, drive a car and own a house and all those things. And it's just like pulling teeth. So there's so many pieces that are definitely sort of falling within that definition of family violence in a lot of the cases. And so I wanted to pull out that example. And last piece, in 2021, the Supreme Court of Canada released a decision called Kaluki v. Kaluki that, Vicky Law, you can tell us more about your advocacy in this case, but it's so amazing that RISE was sort of a part of it because West Coast Leaf intervened. So I'll read this and then give a bit more background, but what the Supreme Court of Canada said, courts and legislatures have also implemented various mechanisms to incentivize and even require regular ongoing disclosure of updated income from the payer, along with tools to move proceedings forward in the face of non-disclosure. Those mechanisms including imputing income to payers who have failed to make adequate disclosure, striking pleadings, drawing adverse inferences, and awarding costs. By encouraging timely disclosure, these tools reduce the likelihood that the recipient will be forced to apply to court multiple times to secure disclosure. So the whole case, hopefully will improve some pieces of financial disclosure in family law. It definitely is a huge win for scenarios where people are trying to say that they don't owe retroactive child support, which was the facts in this case, was that the person who was the father came and had this case that he shouldn't have to pay his $175,000 of retroactive child support because, in fact, his financial circumstances had changed. So somewhere in those years that he was owing, he said he shouldn't have to pay as much. And long story of appeal decision and Supreme Court decision short, the court said, you can't really just say that. X amount of years later, it was your duty to show why your financial situation had changed and why you should have been paying less. And now there's a whole test to go through whether or not you should pay less, but because you really made absolutely no steps, you should just have to pay the whole amount, which is even a win on top of the appeal court's decision, which said, okay, you can pay $136,000. The Supreme Court said, no, you can pay $175,000. There's really no reason that you shouldn't have, your children have been impacted by this for a long time. So that sort of concludes my brief overview of the provincial forms. I didn't go through the actual forms themselves. I had thought about it, but I just pictured me scrolling through forms and it maybe not being super beneficial.